Well, good afternoon, everyone. Welcome to our fourth Notary Town Hall of the year. Hope everybody had a good summer, and we enter the fall here. We're picking these back up, a couple more after this for Notary topics later this year. And thanks for joining us today and spending a little time with us this afternoon. And as normal, today's town hall is going to be recorded. It's going to be posted on the main Notary Public page of the Secretary of State's website. So if anybody was ever trying to find these recordings, if you go to SOS, like Secretary of State, .Maryland, Maryland is spelled out, .gov, sos.maryland.gov, and towards the top of the page, the words Notary Public. You scroll down a little bit, you'll see all these recordings as well as other information of value on our website about how to apply, how to renew, run vendors, et cetera, et cetera. That's the main page you want to visit when you're looking for notary information as it pertains to the Maryland Secretary of State's office. Today also, this recording is for informational purposes only. It is not intended to be legal advice. Today we're going to talk about something nobody ever wants to have, which is a complaint against them. Some of the top 10 mistakes that notaries make. Some of these will probably seem really obvious to many of you, but they're made, and they're made pretty regularly. And these are things folks do more than they probably should that can find themselves in trouble with us or with others they notarized for. And at the end of the day, if you know how to do your stuff and do it right, hopefully you'll never have this experience. But thanks for joining us today. And as always, there's a chat box to the side there. If you want to throw a question in there, please do. Always, caution. We're going to cover a lot of territory here today. Your question might get answered during the town hall. So be patient on that. There might be answers there. If you don't find your questions answered, throw it in that chat box. At the end, some of those frequently asked questions, we'll have one of our notary officers read out, and we'll talk about it a little bit. If it's something you ask in the chat box and it's not entered by one of us today, feel free to email us on the side about that question so we can help you out. I mean, our ultimate is to try to help folks and get you the best information we can get to you. I just threw the email inbox address for the town hall, townhall.sos@maryland.gov. If your question isn't answered today, and we'll do our best to answer them all. But if it's not, send me an email on the side to that town hall box, and we'll get them all answered that way. If we don't successfully do that here during this town hall, we'll hold some time at the end as well, so folks can raise your hand, so to speak, and just ask the question out loud, and we'll talk through some of that as well. And as we always mention, also ask questions in that chat box. Do not answer them for folks. Many well-intentioned individuals tried to answer someone else's question in that chat box and gave the wrong answer. That information can maybe lead to some bad choices. So that chat box is for asking questions, not for answering them. Unless you're one of our notary officers, you should not answer a question that's in that chat box. So please ask them. If you're from the public, do not answer them. We'll answer them. And like I said, if we do miss them, you can always hit us up offline, and we'll answer those questions. And at the end of the day, it's really outreach. One other question we get asked a lot leading into these town halls is this required? Nope, it's not required. It's an attempted outreach by the Secretary of State's office to our notaries just about common themes and topics we get asked about on a regular basis, so we can convey some more information to you. This is not the course of study that's required to become a notary or renew. This is just voluntary participation in the town hall where we talk about certain subjects of interest to notaries. And if anybody has any suggestions for Maryland notary topics, you can throw it in the chat box as well. We do read those the chat info and see what information we can take from that when we're doing these town halls. But if you have any good suggestions for Maryland notary town halls, let us know. And if it's within the scope of our authority and we can take that on, we'll consider that and do that. But I mentioned for Maryland notaries, they asked a question about notaries the other day, and in response to the invite, if you have a question about being a notary in another state, talk to that state's notary licensing office. They're all different and unrelated. And last kind of disclosure, so to speak, on here, one of our most frequently asked subjects is what folks commonly refer to as a loan signing agent or notary signing agent, which in Maryland is called a title insurance producer. If you have title insurance producer questions, you will want to ask them to the Maryland Insurance Administration, not the Secretary of State's office. We do not regulate title insurance producers in Maryland and can't answer questions. They are outside the scope of our authority. Maryland Insurance Administration is the right one to ask. We'll have a joint town hall with them a little later this year as well to talk about some of those differences between being a notary and a title insurance producer and some of the stuff that goes with that. So there will be a town hall later. Again, just started, this town hall is being recorded. By participating in the town hall, you are consenting to that recording. That recording is going to get posted on our website here, usually within a week or so of the town hall occurring. And the information here it's for informational purposes only, not advice. So a lot of opening and greeting. Let's get started and talk about what you actually came to hear about today, which is some notary public stuff and avoiding complaints. Number one mistake. Lead with this one. It happens all too often, and that's just basic commissioning errors. If you all been sworn in, you managed to get in there in time, but those of you thinking of renewing soon or that are going to have just renewed but haven't picked up your commission yet, get to the courthouse, get sworn in within 30 days of the issuance of your commission. The law says the commission's issued, you have 30 days to get sworn in. Make sure you get there in the 30 days. If you do not, it is revoked and you would have to reapply. We don't want you to have to reapply. We don't want to have to revoke it. Please help us help you get there within the 30 days. You also can't have somebody else pick it up. It's a commission that's issued in your name individually, right? I'd be Mike Schlein, notary. I'd have to go get it. I can't send my assistant. I don't have one anyway. But couldn't send an assistant or coworker or something to get it. It's not how it works. You need to go get your own commission and take your own oath of office, and then somebody else cannot do that for you. You'll hear that theme a little bit later when we talk about notary seals and making sure you keep them secure. Get that commission in time. When your application is approved with us, you're going to get an email telling you it is approved. Check your inbox. Those emails go to the email address of record on that application. Make sure that email address is correct when you're putting it on the application. You'd be surprised at how many times it's not, and that's why people don't see them. Check your spam folder. It might be in your spam folder. But generally speaking, if you submit a renewal application, you're going to hear back from us within 1 to 5 days, often on the lower end of that. Usually 2 to 3 days before your renewal has, a determination's been made on approving or denying it. So if you submit a renewal application and you're waiting more than a week, you should check in with us. Make sure you did not miss that approval email. Check your spam folder, see if it's in there. If you're not seeing it, check in. Maybe something's wrong. Maybe it's incomplete. Maybe there's a problem with the app. But if there is, you'd have heard from us about that as well. So be proactive is the bottom line. And, make sure you're checking your inbox and checking in with us if you don't hear anything new. Notaries, usually not much more than a week or two at most. I always tell folks that are new applicants, if you haven't heard anything in 2 weeks, call and check in. Why do I say that? Well, it might take a little longer as a new applicant, but at the end of the day, if you check in 2 weeks, even if you were approved 2 weeks ago, that still leaves you 2 more weeks to get sworn in, right? So don't apply and just let it sit and go away and forget about it. Check back in if you don't hear anything in a couple weeks as a new applicant. week if you haven't heard anything as a renewal applicant, because it either should be approved or we should have emailed you asking for more information about whatever it is within that time frame. But bottom line, don't wait more than 30 days. Go get that commission. We ask you to uphold the law. We got to uphold the law as well. And we don't enjoy those calls. Nobody enjoys getting them. Just get there in time so we don't have to deal with a possible revocation of that commission and making you reapply. The number two, again, I mentioned some of these seem pretty obvious in terms of you should do these things. The second mistake that we run into is when folks are notarizing, failing to identify signers. You must always identify the person requesting a notarial act each and every time. There's a few different ways you can identify somebody coming before you to get a notarial act done. The most common way of identifying somebody, government-issued identification. Passport, driver's license, consular ID, government-issued non-driver ID card. Another form of government ID that's issued containing the signature and photo of the individual, and that is also satisfactory to the notary public. Usually you're going to see a driver's license or a non-driver ID card. Somebody could give you their passport. Those are the main things you're going to see. Every now and then somebody will ask, does the driver's license have to be current? No, not necessarily. Nothing in the law requires it be a current driver's. If it's expired and it's still satisfactory to you, you can use that. Second way of identifying folks, personal knowledge. You have personal knowledge of the identity of the individual that is appearing before you. Appearing before you, if you know who they are and you've had sufficient dealings to provide a reasonable certainty that the individual has the identity claimed, you could identify them just by means of knowing who they are, personal knowledge of identification. Does that mean anybody you've ever met? No, not necessarily. Dealings sufficient to provide reasonable certainty that the individual has the identity claimed. Do you know them or do you know them? Those are the folks that personal knowledge. You know them, you know them, you know about them. You've dealt with them more than just in passing. You have dealings sufficient to provide reasonable certainty that they are who they say they are. A third way of identifying somebody is called credible witness. You may identify somebody that's a credible witness to the person requesting a notarial act. So if I were to show up before a notary and I don't have some type of identification and there's a credible witness that can identify me to the notary, that's one way of identifying somebody. You need to get that credible witness's identification, though, and you need to record that in your journal because that is instrumental in documenting that you did your job, did the best you could. It would tell you that most folks have a current or expired driver's license or government-issued non-driver ID. Most folks have that. If I drove to you to get something notarized, right, and I drive to you to get something notarized, and I tell you I don't have a driver's license, I got other problems, right? A reason to be skeptical of that idea, and so your antenna should be up. You're looking for red flags and in terms of identifying people, and that'd be a pretty good red flag to notice there, right? I drive you, I tell you don't have a driver's license, you can't identify me that way. Well, something's not right. They got bigger fish to fry if that's the problem, right? So maybe they should get that driver's license, then come back to you. Certain situations, it might make sense, right? Identifying a minor. They may not have a driver's license. They may be under 16 or not even a learner's permit or something like that, right? You might have to use credible witness to identify somebody in that situation where there's maybe a really good reason they don't have a government-issued photo ID card, be it driver's license or non-driver ID card or passport. So many minors don't have IDs. You may run into that scenario there. You may be able to use one or two credible identifying witnesses in lieu of that ID. But again, if government issued ID, personal knowledge, those are probably the two main ways you're going to identify folks. Credible witness, there's some scenarios you probably play it in your head where you go, okay, that makes sense, versus somebody just doesn't feel like showing their ID card, where it doesn't make a whole lot of sense that they wouldn't have one. I just saw a little chat pop up. I won't always see this, but somebody asked about student IDs. Student IDs would not count unless it's a government issued ID that contains both their photo and their signature. Think back to like my college ID card, it had my picture but not my signature, so it would not count, even though it was a state school that I went to. It would not count because it did not have my signature. So government issued photo ID that has both your signature and your photo on it, that's what would count. If it was a government issued photo ID and it had both of those things and you, the notary, knew what it was and knew that's how it's supposed to look, hey, if it's sufficient to you, the key phrase there at the end is, and is satisfactory to the notary public. If you didn't go to the school I went to many, many years ago and did not know what that school's ID looked like, but it still had a photo and my signature, but you didn't really know if that was a legit ID, then that would be grounds to say no thank you. You can't really know. Can't satisfactorily identify me, but even then, my ID didn't have a signature on it, so it wouldn't have counted anyway. It was, passport, driver's license, government issue non-driver ID card are the big ones that you're going to use. This one is a frequent topic. One of the biggest questions we get asked on these town halls about what can a notary charge? And we're going to address that right here because a lot of folks will overcharge. And you could face anything up to revocation of if you do this. Right now, the fee that a notary can charge per notarial act is $8. So if you're notarizing for a few people and you're identifying every one of them and you're watching them all sign and you have a journal entry with all their names on it, $8 a person that you're notarizing for. So for each notarial act, it's $8. Additional copies of the same document, $4. So if you're being asked to notarize the exact same thing for somebody, $1 for the first, $4 for the second, $2 if you're asked to make a copy of it. You are allowed to travel to perform notarial acts. Folks that travel to do notarizations often call themselves mobile notaries. It's not a separate category. It's a term folks use. It's not a thing in the law. The law doesn't identify what is a mobile notary. It doesn't matter that you travel or don't travel. It's not a separate license. It's not a separate thing. They are a notary, like any other notary, and are subject to the same fee requirements of every notary. If you are traveling, though, you can charge mileage plus a fee of $5 to travel. So, and I'm going to go over that scenario in a second. Remote notarial act, $30 per remote notarial act. So if we're in a scenario here where I'm being asked to travel to notarize for you, let's say my trip is 20 miles for the notarial act to visit you and back, round trip, right? I traveled to you to notarize, and it's 20 miles that I traveled in total. I can charge $5 because I had to come see you, plus mileage rate at 20 miles. So I can't remember what the current IRS business travel mileage rate is, but 20 miles times that mileage rate plus $8 per notarial act. So $5 because I went somewhere, plus mileage, plus $8 per notarial act. A lot of folks see the $5 fee and they go, oh, I can only charge $5 for travel. Well, $5 as a base travel fee plus mileage plus $8 per notarial act. So hopefully that provides some clarity. There's a town hall from earlier where we talk about the fees somebody can charge, and we give a detailed breakdown of a scenario like that. If you're looking for more information, go to sos.maryland.gov, go to the notary page, go down to those town halls. and fees, and make sure you check that out because it goes into more detail about that situation and how to charge and how to properly charge. The number one question folks ask is, yeah, but can I charge a convenience fee or an after hours fee or I did it on the weekend fee? No, no, no. These are the fees you can charge. Doesn't matter what time of the day it is. If you want to answer your phone at 2 in the morning and travel for a notarial act, still $5 because you went somewhere, still plus mileage, still plus $8. There's no after hours fee and things like that. You cannot do that. But we always get a lot of questions at the end asking about all these other terms people use to charge more money. You can't do that. These are the fees you can charge. Don't charge more than that. Doesn't matter who you are, where you're at, what time of the day or night it is. These are your fees. These are your fees. So make sure you know these, and that's why I'm kind of hanging on this install for an extra minute. Get a good look at those. That you can also find if you go to sos.maryland.gov, click on the notary page, see some links on the left-hand side of the website. One of those links is for frequently asked questions, and there's a good breakdown of what you can charge there as well. Should you be unsure, it's all out in the handbook that we have for notaries. Mistake number 4, we run into journal entries, journaling. Folks that have been a notary a long time remember it being called a fair register of official acts. That's what it is. You are required to maintain one by law. You have to have a journal. It must chronicle all notarial acts. Each and every act, pause and let that sink in for dramatic effect. Each and every act must be entered into your journal. Whether you notarize once a day, once a month, once a year, each and every act. Whether you notarize for different people all the time or the same person every time, each and every act must be chronicled in your journal. Folks fail to accurately document the journal or make a journal entry at all or do it at the time they perform the notarial act. The journal requirements that's done contemporaneously with the act. So at the same time, place, and occurrence, right? That's contemporaneously. So while you're there identifying folks and watching them sign and notarizing their document, you should be completing your journal entry. Folks will say, I got to do all that every time, each and every time. Yep. Takes so long. It takes like 30 seconds to a minute, right? You got that much time. You can make that happen. Maintaining multiple journals on tangible records. So if you're doing tangible records, in other words, traditional notarial acts on paper, you can only have one journal for that, right? Can't have several journals to chronicle your acts on tangible records. Whether it's a hard copy journal or an electronic journal for those notarial acts, can only have one, just one journal to chronicle, man, I can't say it right, chronicle each and every notarial act on tangible records. If your journal's lost or stolen, let us know, right? We want to know. We want to know, and we want to know when you discover that, because if that comes up later, right? If it comes up later that it's lost or stolen, we have no ID and you can't provide it. Right? What are we supposed to know or believe, right? So make sure you let us know if it's lost or stolen. For remote notarial acts, so you notice on it talks about maintaining multiple journals for notarial acts on tangible records. It's a problem. If you are performing remote notarial acts, you could have more than one journal to chronicle those remote notarial acts on electronic records. So if you're performing remote notarizations and you're using a RON vendor to do that, you're performing remote notarial acts on electronic records, you may have a different journal depending on what platform you're using, right? So you could have more than one secure journal that are chronicling your remote notarial acts on electronic records, only one at a time when your tangible record notarizations Folks will often say, but I ran out of space, Mike. Well, start that next journal, right? Start that next journal. Keep your old one. Got to keep that journal for 10 years. 10 years. Each and every time, 10 years. Does 10 years mean from the first entry? No, 10 years from the last entry in that journal. That's how long you have to keep it. So if I have finished my journal today and I filled it up today, I got to keep that journal of my notarial acts for tangible records or remote records, whatever it is, both for 10 years. 10 years from the last notarial act that is chronicled in that journal. Keep it secure. Say that if I had $1 for every time somebody's journal was damaged because they left it on their floor in the basement and it flooded, I'd have a lot of money. Don't keep it on the floor in the basement. Don't keep it under the sink. Keep it somewhere secured. Put it in a file cabinet. Put it in your desk. Those journals, yay thick, right? The paper journals. Keep them. You can keep them. You can find a place to store them comfortably. I used to jokingly say use it to prop up the uneven leg on the table, but it might get damaged. So keep it somewhere safe and secure. Don't let it get damaged. You don't know when you'll need that. Hopefully you'll never need it again. But should somebody ever ask, you have your journal that you're required to keep for that length of time, and you can answer any questions that may ever be asked of you. Each journal shall contain certain information, date and time of the notarial act was performed, description of the record, and the type of notarial act. That's two different things, right? Description of the record is what's the document you're notarizing. Type of notarial act is, did I do an acknowledgement? Did I do an oath or affirmation? Did I do official witness? Did somebody attest to a signature or copy? Right? So description of record and type of notarial act. Full name and address of each individual for whom the notarial act is performed. Right? Full name and address of each individual. If the identity is based on personal knowledge, a statement to that effect. So, note how you identify them. Did you use ID? Did you use personal knowledge? Did you use credible witness? How did you identify them? If it's from personal knowledge, you need to note that. If it's based on satisfactory evidence, i.e. identification credential, note the date of issuance and expiration of that identification credential. Also note the ID number of that identification credential. Like if it's a driver's license, there's a driver's license number on there. For those of you that have a Maryland driver's license, don't answer out loud, but just think to yourself, do you even know your own driver's license in full? Most people don't. As a notary, if you've identified somebody properly and you identified them by driver's license, you got their driver's license number in your journal. It's pretty good evidence that you identified them for the purpose of notarizing. I don't know my own driver's license number. I know that. I know like the first 4 to 7 characters, right? There's always somebody that knows it. There's always somebody that's smarter that knows their number, but right, most of us don't. If we're being honest with ourselves, most of us don't. So you got it as a notary in your journal. You definitely identified them. Fee charged, if any, by a notary public. If no fee charged, note that there's no fee charged. We just talked about fees on the prior thing. So now we know what to charge, right? But if there's no fee charge, note it. And the thing to remember about fees is you can charge up to those amounts. Some folks don't charge at all. That's totally fine. Up to $8 per notarial act. Up to $30 for a remote notarial act. You can charge less. You just can't charge more. And as far as fees go, one other thing I didn't think of on that last slide is the way it's written is you cannot demand and receive more than $8 per notarial act. So no tips as well. Folks, what if they wanted to tip me? Nope. No tips. Demand and receive not more than $8 per notarial act, $30 for a remote notarial act. So cannot take more than that amount. Last item here on the journal here is indicating whether or not it was notarization that was done in your physical presence or if it was done remotely. So if you did a remote notarial act, you need to note that it was done remotely in your journal. So we talk about if you're keeping a journal on a tangible medium, it must be permanent, bound, register with numbered pages. So if you're keeping a tangible journal, a paper journal, to chronicle your notarial acts on tangible records, that book must be permanent, bound, register with numbered pages. Again, only one journal at a time for those tangible record notarizations that you're logging. If you're keeping your journal electronically, and then it must be tamper evident electronic format. So really secured electronic journal. Again, if it's tangible records that we're journaling, one journal at a time, tangible or electronic. If you're chronicling notarial acts for electronic records, you could have more than one at a time. Again, you might want remote notary technology to remotely notarize. And the vendor may have journaling as part of their platform, and so if it's a remote notarization on electronic record, you may have more than one electronic journal sitting out there that you have access to. But again, secure, tamper evident, electronic format. Those RON vendors, how do I know if it complies? Those RON vendors have met the requirements to be authorized for use in Maryland. So their technology should meet the requirements if you're using their platform for journaling as well. So number 5, what do we run into? Notary stamping device errors. I referenced this, alluded to this a little earlier. Your notary seal is what folks normally refer to this as. The law calls it notary stamping device now. But things folks do, it always surprises me. They maintain and secure the stamping device. Keep it safe. Know where it's at. Don't let others use it. You cannot allow someone else to use this thing. So the mistake, the error folks make is they allow someone else to use their stamping device. They get a stamping device with bad information or incorrectly printed. It's got bad info on it. Your stamping device must contain at least these 3 things. Must have your name as it appears on your commission. And if I'm Michael Schlein, Notary Public, that's what my seal must say. Can't say Mike. Can't say MS, M Schlein, what have you. It's got to say my name as it appears on the notary commission that you got when you sworn in at the courthouse. It must have the words Notary Public on it. And it must have the county in which you were commissioned, or if you're commissioned in Baltimore City, Baltimore City. Can't say Baltimore City County. You either were commissioned in Baltimore County or Baltimore City, not both. That is a thing that I think we've seen more of lately. Baltimore City and Baltimore County are different jurisdictions, different courthouses. It's not the same. So make sure your notary seal reflects the jurisdiction you were sworn in properly. Take your stamping device. If you change employers, it's yours. It's got your name on it, right? It's got your name on it. It's yours. It's not the company seal, whether they paid for it or not. It's your seal. It has your name. It's yours. It goes with you. It is yours. And so we run into every now and then. We can't really advise you on how to squash some type of issue that your employer has with you and they paid for your seal. We can't really get involved in that, but our handbook spells it out clear as day for folks that are unsure. It's your notary seal, your seal. Again, it's got your name on it. So if something goes wrong, who are they going to ask? They're not going to ask your former employer. They're going to ask you. Take it with you when you leave. Take it with you when you leave. Let us know if it's lost or stolen, just like the journal, right? And let us know. If your seal is stolen or lost, as soon as you find out, let us know. Send us an email. Let us know your seal is lost or stolen or what have you, so we can record that and know that for future reference should that ever become a problem. I've had folks that have had their notary seal taken, and 3 years later, it showed up on documents that they never notarized, right? So it could happen. But we were able to get out ahead of it. We knew the notary hadn't done it because we knew what seal was taken, we knew when it was taken, and we knew they told us what it looked like. So it was great. And when they got a new seal, they got one that looked slightly different. They went rectangular instead of circular, or squared instead of rectangle, whatever it is. They did something slightly different, but the image of the seal, so that it was clear it was a new one and not the same one that was taken. So it is it's a thing you want to keep track of, and you want to know that you have it. You want to know you're the only one that has it. Don't let anyone else use it. You cannot let anybody else use it. People have had commissions revoked because they've let other people use their notary seal. If you keep it at work, keep it locked. We love our coworkers, hopefully, right? We like them. We get along with them. They might be great people. You might have a great time with them. But if you leave that notary seal on your desk when they're not around, sometimes that temptation might be too great. Don't let anybody else use it intentionally or accidentally. Don't let anybody else use it. It's your seal. It's got your name on it. That's who people ask. Like I said, kind of at the beginning of the slide, notary seal, notary stamping device. It's just the law calls it notary stamping device now, formerly called notary seal. And it could be an embosser, so the raised paper mark, and it can be an ink stamp. Either one is sufficient. Either one will work, ink stamp or embosser. So just a little more information here. Got a little ahead of myself on this slide. We talk about it. Both are fine, right? Both are in general use. Both are totally fine. And, again, let us know if it's lost or stolen. If you resign or your commission's revoked, hopefully not, right? But if you resign or your commission's revoked, or you just expire and decide not to renew, make sure you render that seal unusable. If it's a ink stamp, it's usually pretty easy, right? Peel off the rubber stamp part and break it into a bunch of pieces. Those embossers are sometimes hard to damage or render unusable, but do your best to make that not usable again. So incorrect in-person notarizations. One of the other things we run into here is, what are you actually doing as a notary? There's the last town hall we did talks about all these types of notarial acts in great detail. I'm not going to spend a lot of time in great detail on these. If you want to learn more, watch that last town hall we did about the different types of notarial acts and notarial certificates. But you can take acknowledgments. You can administer oath or affirmation, verify on oath or affirmation, witness or attest to signature, certify or attest to a copy of something being a true copy in someone's possession, protests. That last one you're not going to see very much of. I still haven't run into a lawfully done protest. It's not a thing that you really see in today's day and age. The overwhelming majority of notarial acts you do are going to be acknowledgments, oaths and affirmations, witnessing or attesting signatures. There's certain certificates you would attach if it's not already present on the document itself to signify that's the type of notarial act that you were doing. So this is what you can do. You can't marry people. In some states, a notary can marry somebody. Not in Maryland. That's not a thing here. Notaries are a little different in each state. Very similar in most ways, but a little different in every state. So make sure you know what your actual powers and authority is. Don't go outside of that and promise to do something that you don't actually have the authority to do. I've heard some good ones over time. Somebody said that they can certify the opening of a bank vault. Don't even know what that means. But no, that's not the power of a notary. Folks have tried to marry people as a notary. In some states, that's actually a thing. Not in Maryland, that's not in your authority. As a notary public, can't marry folks. So know your actual powers and authority and stay within those. This is what you can do as a notary. This is what you're tasked with doing. So in-person notarizations, tagging along to different types of notarial acts. When you're a notary, you're always going to be, if you're in person notarizing, so again, if you're not remotely notarizing, but if you're in person notarizing, you got to be in the same physical presence as the person requesting that notarial act. In the same room, together, face to face. Identify that signer, or it says using valid government issued ID, but and could be other methods, right? Personal knowledge, stuff like that. You witness the signing of the document, or they attest to the fact that they signed it. Depends on the notarial act. Again, for more info, watch that last town hall and read up on the types of notarial acts in the handbook. Acknowledgments and attesting to signatures, you don't necessarily need to watch them sign it, right? Because they're not, the certificate's not saying that. But if the certificate says you witness them signing it, they need to sign it in front of you. If you see sworn and subscribed before me, that's an oath or affirmation. But if it's done before you, right, sworn and subscribed to before you, so they would have to have signed and sworn to that in front of you in person. So it depends on the type of act. Fix your seal and execute the notarization, and enter the notarial act in your journal. Those are the things you're doing each and every time that you perform one of these notarial acts. Here's your notarial acts. It's your basic steps every time you do a notarization. Electronic notarizations, almost the same as your traditional notarial act, except for it's electronic. Instead of on a tangible medium like paper, it's done on a computer. Still personal appearance, still in the same room, still identify, still watch them sign if needed, etc., etc. There's something called remote notarial acts that's a little different than this, and I'll touch on that real quick a little later on here. But electronic notarization functions the same as your in-person notarization, except for that things are signed and sealed electronically rather than on a paper document, which is different than remote notarizations when you are not in the same physical presence, but you're using certain authorized technologies to identify people remotely and watch them sign remotely according to the laws. There's an entire town hall, by the way, about remote notarial acts coming up later this year. So notarial acts within the state of Maryland. Folks, become a Maryland notary and can only notarize in Maryland. Can't use your Maryland notary seal in another state. Can't go to DC and use it. Got to be standing in the state of Maryland when you use your Maryland notary seal. You think about that. You only have jurisdiction to notarize in Maryland, right? Like myself as a state employee for Maryland, I can't go to another state and tell them how to run their government or their office or whatever, right? I don't have the authority to go do that. I'm just another person when I go to that other state. I'm not a state employee of that state. I'm a state employee of Maryland. So your notary commission, your Maryland notary commission, is good within the state of Maryland, anywhere within the state of Maryland. Doesn't matter where you were commissioned in Maryland, you can notarize anywhere in Maryland. Say, for instance, I was commissioned in Baltimore City, and I'm a Maryland notary commissioned in Baltimore City, and my seal says Michael Schlein, Notary Public, Baltimore City. If I'm on vacation down in Ocean City, I can still notarize because I'm within the state of Maryland. Anywhere in the state of Maryland, I could be on vacation up at Deep Creek. I'm sitting in the state, same thing, I'm in Maryland. I can still notarize with my Maryland notary seal. The moment I step across that state line into another state or in the DC, I can't use my Maryland notary seal. I'm not authorized to notarize outside of the state. I have to be physically present in the state of Maryland. It doesn't matter what combination of county you were commissioned in and where you're at the time. The truth holds, whether you're commissioned in Prince George's County and standing in Baltimore City, or commissioned in Howard County and standing in Montgomery, or any other combination, if you're commissioned as a Maryland notary, you can notarize in Maryland. The other thing to think about is the document you're notarizing. Doesn't matter where it's coming from or going to, as long as you're in Maryland. Folks often will say, well, okay, I got to be in Maryland. I get that, but this person's on vacation. They're from California and they're here in Maryland, and something happened with their family. Can I notarize something that they're going to use in California? Sure. As long as you're standing in Maryland when you do it. As long as you're standing in Maryland when you do it. If you want to notarize in another state, go become a notary in that other state. It's not reciprocity. If you're a notary in another state, you don't automatically become one in Maryland. And if you're a notary in Maryland, you don't automatically become one in another state. You would have to apply to be a notary in that other state and become a notary commissioned by that state as well. in order to notarize in that other state. So again, we just talked about the different types of notarial acts a couple slides ago. This is what you're allowed to do as a notary public when you're standing in the state of Maryland. Can't do this outside the state of Maryland, only in the state of Maryland. From the mountains to the shore, everywhere in between, north and south, as long as you're standing in Maryland, you can notarize. Conflicts of interest, avoid those conflicts, right? Whether it's real or perceived. Avoid notarizing for family members. That's not an outright, no, you can't do that for every family member. The way the law is written, a notary may not perform a notarial act with respect to a record to which the notary or the notary spouse is a party, or in which the notary or their spouse has a direct beneficial interest. Notice it just says you're basically yourself or your spouse. Can't notarize your own signature or your spouse's signature. Can't notarize for something you or your spouse have a direct beneficial interest in. But I'm going to tell you, just don't notarize for family in general. Don't notarize for your siblings. Don't notarize for your kids. Don't notarize for your parents. There's 80,000 notaries in Maryland. Go find another notary that's not an interested party. As much as you may not technically be an interested party and you can notarize for your sibling or your cousin or whatever, family stuff. Many years ago, I used to handle the complaints that we'd get about notaries public. And I can tell you, I don't have an exact amount, but I bet you at least half the complaints involved a notary that notarized for another family member. And the complaining party is yet a different family member. It's all good until it's not. So just don't. Don't notarize for other family members. Sad things happen, bad things happen. Somebody passes away, they have a lot of money or property or something, and they leave it to folks, and you're related and you notarized for them or for some other thing related to that. Susie took care of grandma the whole time, and little Johnny was nowhere to be found, and grandma leaves everything to Susie, and Johnny's mad, and just get somebody that's not a relative to notarize, right? Don't notarize for family. Stay away from family notarizations. Your only duty to refrain is yourself and your spouse. But I hope I drilled this point home enough. There's a lot of notaries out there that can notarize for you or your family members. Don't notarize for your family members because if it is something about that type of stuff, unfortunately, ugly things can happen after the fact. You can't predict that. So better to stay clear and free so that you don't get dragged into that family drama. You should also refrain for matters again in which you're personally involved, even if indirectly, or where you have no beneficial interest. If you think you're involved in this thing, just don't notarize it, right? Don't notarize it. The notary should be that independent third party. They're really witnessing these signatures, making sure everybody says they are who they are. Stay out of it if you think it may involve you somehow. Send them to somebody else. Folks will sometimes ask, well, I'm a notary at my job. I work at a bank. And sometimes I have to notarize things at work. Can I do that? Yeah, of course. Yes, you can. I know you work at that bank and they pay your salary probably, or whatever the company is, insert whatever company for bank, but you just can't notarize for yourself and you can't notarize for your spouse. Those are the two hard and fast no's to conflicts of interest. But again, if you think it's a conflict, stay away. If it could be a conflict, stay away. Save yourself that time and headache. So things are great until they're not. Just don't be involved if there's even if it's a perceived conflict. Exceeding the statutory authority. So there is some stuff you can't do as a notary. Can't draft legal records, can't give legal advice, can't practice law, can't say you're an immigration consultant, can't represent somebody in judicial administrative proceedings, can't receive compensation for doing any of those things if you're a notary public. Well, Mike, I'm also an attorney. Great, then you're an attorney, right? You're doing those things as an attorney, not as a notary. So you can do them if you're an attorney. But if you're just a notary and you're not an attorney, you're not a licensed attorney in the state of Maryland, you can't give this stuff. You can't give legal advice. You can't draft legal records, right? You got to be an attorney, or what's the phrase, under the supervision of one, whatever that is exactly. But if you're not an attorney, don't give legal advice. You're a notary, you're notarizing, right? Don't advise people on the best way to do a will. You may think you're trying to help because you've been through the situation before. They should talk to an attorney about that. It's a, it's don't give legal advice, right? I guess that's the best way to say it. You try to help somebody and give them a friendly tip or thought because you happen to be notarizing something for them, and that friendly tip or thought goes wrong, and who they're going to come back and talk to might want to come back and talk to you. So don't give legal advice, unless, of course, you're an attorney, in which case that's your job, right? You're giving legal advice. The last one here on the list of 10, failure to, and I'm going to go over a couple little matters of housekeeping as well. Failure to affix the notarial certificate. If anybody's been a notary a long time, this never used to be a thing until October 1st of 2020. It used to just be that if the certificate was on the document, you completed it. And if it wasn't, you did notary as official witness. Now, if there's no certificate, notarial certificate wording on the record that you're notarizing, you must attach a certificate because every notarial act requires a notarial certificate. That notarial certificate is saying where it was done, what day it was done, who it was done for, what exactly you, the notary, were doing. Was it an acknowledgement, oath, affirmation, witness? The handbook has examples of certificates that generally it should have as a bare minimum. The certificates don't have to match the handbook exactly, but that's generally speaking what a certificate should have as a minimum. It's found, and those certificates in the handbook are pulled directly from the law. So it gives some examples of what they need to include at a minimum there. Look at those certificates. There should be that wording on the record that you're notarizing, and if there's not, you would have to securely attach to that document a certificate. Folks often ask, what does securely attach mean? Well, securely attached, that could be many things, right? Attach it, the certificate wording, to the record you're notarizing in some way, shape, or form. This is not specified in the law exactly what the options to securely attach are. That certificate, just like that journal entry, should be completed contemporaneously with the performance of the notarial act. Be signed and dated by the notary. Identify the jurisdiction in which the notarial act is performed. I'm going to go back to that in a second. Contain the title of the office of the notarial officer. So for you, it's notary public, which will be on your seal. And your expiration date should be on that notarial certificate as well. I said I was going to go back to this one. Identify the jurisdiction in which the notarial certificate, the notarial act was performed. What does that mean? Well, what that means is, where were you when you notarized? I gave an example earlier saying, if I was commissioned in Baltimore City, and say I was down Ocean City at the time and I notarized something, my notary seal says Michael Schlein, Notary Public, Baltimore City, right? That's where I was commissioned. That's what my notary seal says. But if I'm in Ocean City, that notarial certificate should say State of Maryland, County of Worcester, because I am in Worcester County when I'm notarizing. And that notarial certificate is explaining, it's telling the story, right? It's telling the story of what happened, who appeared before the notary, what type of notarial act was done, what day was it performed on, where were you when you did this, what county were you in? You were in the state of Maryland, Worcester County in that example. If I'm in Baltimore City when I notarize, it's going to say State of Maryland, City of Baltimore. Montgomery County, State of Maryland, Montgomery County, County of Montgomery. So that certificate is going to say where you are at, not where you were commissioned. Your seal says where you're commissioned. The certificate is saying where you're at because it's explaining everything that was happening at that point in time where you notarized for them. A few more things here. Notarial act, you got to identify the person. You got, if it requires watching signature, acknowledgement, oath, whatever, you need to administer that and do that. Watch them sign, or if they've attested to the signature, and that's in those scenarios, before you can complete the notarial certificate. Can't complete a certificate saying somebody came before you if they did not. Right? Can't say you identify them properly or have personal knowledge of their identity if you do not. Right? By completing that certificate and affixing your seal, you are saying you did your job and you verified they are who they say they are. So as a couple of, electronic records from notarial acts, says affix or logically associate. That's wording that's meant to incorporate electronic records that can be notarized. The certificate shall be affixed to or logically associated with the electronic record. Before we get into questions, just kind of talk on a couple of things real quick. We talked about in-person notarizations and electronic. We didn't really touch on remotes. We're going to have a whole town hall about that here soon, about what's a remote notarial act. But in short, there are technologies that allow you to identify people, watch them sign electronic records remotely, notarize it electronically, remotely, all in real time. It's basically a way of doing it while you're in two different places, but still keeping all the things that the in-person notarization experience has, where you can identify them and watch them sign in real time and affix your seal of the record in real time and keep a journal and make sure they are who they say they are and all that stuff. That's what a remote notarial act is, and it's usually on electronic records. So it is that's something that you can do. I also mentioned, yep. We talk about being a Maryland notary and notarizing. A couple of the things that keep popping up there, and I know we've answered, chat box per signature. What are we talking about when we talk about notary fees? I'm going to touch on that again because, again, fees are the most commonly asked questions. If I'm notarizing for you and you're signing the document and I notarize your signature, I've identified you, I've watched you sign, I've completed the notarial certificate, I make an entry of you in my journal, $8 times that. If two people signed it and I identified both people and I watched both of them sign and I completed both certificates and I have a journal entry for both names, $8 plus $8. That's what that means. All right, that's what that means. Per notarial act, who are you notarizing for? That's what it is. That's what we're talking about. Whoever you're notarizing for, there's a signature on that thing somewhere, right? That's what we're talking about. How many dollars per notarial act? $8 per notarial act. What's a notarial act? Every time you notarize for somebody. If there's one certificate with 4 names, but you notarized all 4 people's signatures and all 4 names are in the certificate, that's 4 notarizations, right? Think about it. You've identified 4 people. You've watched all 4 people sign. You've completed the certificate for all 4 people. You've made a journal entry with all 4 people's names and information in your journal. That's 4 notarial acts. Whether it's, hopefully it's just 4 separate certificates, but if it's not and they lump them all together into one, still 4 acts, right? Still 4 notarial acts. So just being aware of what that means and what that is. If you still have questions, at the beginning of that chat box, there's the townhall.sos email. Shoot an email over to us and we'll go through those questions over the next couple of days and make sure we answer those. In terms of this, what are we trying to talk about? We're trying to talk about different things that folks can do to avoid problems. And at the end of the day, you do the things you need to do, and for the most part, you'll be fine. Do people sometimes file a frivolous complaint with us? Sure, that happens. But if you identify everybody, you always require personal appearance, whether in person or remote. you keep your journal, you complete your certificates, and you generally know your job, you're going to find that this thing can be pretty much a piece of cake, right? Pretty easy if you want to do it right. And we want you to succeed, and that's, like I said, part of why we try to do these things, right? To get that information out to folks to help them. These are the things, believe it or not, these are the things that people stub their toes on while being a notary. And some of you folks that are here are probably thinking, how do they not know to identify somebody or whatever it is? Well, I don't know, but it happens, right? And when it comes to identifying folks, making sure personal appearance, in some of these earlier slides, we talked about different things you do for every notarial act. Here's the slide right here. You're doing an in-person notarization. Folks will come to you maybe sometimes. Well, my spouse is really sick, but they really need this thing notarized. Can you just do it for me real quick, please? You're my buddy. Come on, I know you're notary. Just help me out. They can't be here at the moment. Notarize it for me, please. Don't, right? That person that needs a notarial act needs to come to you. You need to identify them. You need to know who they are. You need to identify them, watch them sign. They need to be in your presence, right? Not their spouse or their brother or their mother or their kid or whatever. Don't let them play the friend or family card. We already talked about that, right? If they play the family card, just don't notarize them at all, right? They play the friend card. Oh, my buddy, I need it. Just do me a favor this one time, please. The answer is no, right? And I'm going to tell you why. The answer is no. I talked about prior duties here dealing with notary complaints. I got I was a sucker for a friend excuse a lot, more than I wish I had. Again, everything's good till it's not. You don't always know what's happening behind closed doors at your friend's house or your family's house or whatever, your relatives. And they got the guilt trip laid on them. They pulled a favor for a friend that they shouldn't have done. And years later, that friend's spouse or sibling or parent or whoever it is filing a complaint with us, and they're engaged in litigation with the other family member that the favor was pulled for. It's not good, right? And the notary didn't do their job right, and they know they didn't do their job right. They thought they were just trying to help somebody. They had the best of intentions. They went about it the wrong way. And I understand that, but don't do that. Don't put yourself in that position because you're the one responsible for your actions on that. But I say that to also remind you that, like many things in life, I won't go down that whole philosophizing road here, but if they're your friend, they will understand why you cannot. They're your family member, they will understand why you cannot. And if they keep pushing and pushing and pushing that you're their best buddy and they need you to pull that favor and not do your job the right way, and you tell them you can't, and you tell them what the requirements are, and they don't respect that, they're not your friend. They're not your friend, right? And I've seen that a lot as well, besides the family stuff. And I remember that and know that. Again, everything's good till it's not. Everything's great till it isn't. You handle your job as a notary the way you need to handle it, and you'll probably smooth sailing through your time as a notary public, as an officer of the state of Maryland, and you'll probably be fine. But just stick to this stuff and stick to what you know. And if you have questions, you let us know. One other thing I'll throw here in the chat box. I mentioned if you email townhall.sos@maryland.gov with a question, if we don't get everything answered in the chat box or here afterwards, you do that here in the next day or so. We'll check it. The town hall email is not checked every day, all day, every day. If you have general notary questions in between these town halls, email dlnotary_sos@maryland.gov for questions. We do want to help you, and that's the email to get the most timely response. Our notary officers are checking that every day. We're responding to emails every day. We're usually back to you the same day, and if not the next, and very rarely longer than that. So if you're in between these town halls and one of these periods where we don't have them, make sure you go to dlnotary_sos@maryland.gov for that question. I'm going to go, Marquita, if you got any common themes amongst your questions, you don't mind sharing with me. Marquita, one of our notary officers here, does a great job all the time on the phones and emails. If you got any common themes you picked up in that chat box you want to share with me, and I'll go over them again.
Okay, hello everybody. One of them by Carrie Boyd. She was asking, can a notary pick and choose who to charge?
That's a great question, Carrie. Thanks, Marquita, for sharing. That's a really good question. Yeah. The law just says up to $8 per notarial act. Folks may have experienced this. We've had folks reach out and go, the bank charged me because I wasn't a customer of the bank. Yeah, I guess. Where some businesses say, well, you're one of our customers, so we don't charge you. We do it for free. And then if you're not a customer, they charge you. Yeah, it just says charge up to, demand and receive not more than $8 per notarial act. If you feel like doing it for free, go ahead.
When I first started, they told us that we either charge everybody or we charge nobody. So, I mean,
you've been a notary a while, haven't you?
Uh-huh. Yeah.
Yeah. Yeah. It's, you see this with businesses across the way. Like I said, in particular, one of the times folks pointed out to us is banks, where they have an account there, they'll do it for free. And if they don't have an account there, they'll charge you the notarial act fee. And that's fine. That's fine. I would, generally be consistent, right? Maybe there's a method to the madness or whatever. And maybe your friend asked you to notarize something and they asked you the right way. So you want to reward them by doing it for free. That's fine. But also too, thinking of that, even if you do it for free, you still got to put it in your journal. I know that was probably implied in one of those earlier slides where it talks about you got to record the fee even if you didn't charge one. But that's a fun one I've gotten before about why somebody didn't have a notarial act in their journal. I didn't charge them a fee. Yeah, still did the act. Good question. What else you got there, Marquita?
Another one is, can you clarify the difference between the verification on oath or affirmation versus administering oath and affirmation?
Yeah, good question. Generally, verifying verification on oath or affirmation is dealing with the credible witness thing. If they're verifying, they're swearing to the fact, and you're verifying that they are who they say they are. Somebody is swearing to the fact that that person is who they say they are, and you're verifying that. Administering oath or affirmation generally deals with the actual notarial act itself, where the person is, the certificate says sworn and subscribed before me. The signer that you've identified and watched them sign and all is swearing to the truth of something on that document. They're telling you that they swear it's true by signing and you completing that certificate. That's administering that oath or affirmation. When we say it that way, we're referring to the notarial act itself, where you're completing the certificate that says sworn and subscribed before me. Good question.
What if the signer is disabled and not able to sign a document, and they want someone else to sign for them?
Great question. I got to go cheat and look up the exact section of the law where this is covered. But there is a part of the law that basically says that, and forgive me if I'm looking away, I'm looking it up on the other screen here. Somebody, if I am physically unable to sign something and I need you to notarize it for me, I go to Marquita. So Marquita, I need this notarized, but I can't sign it. I can bring somebody else with me, and I can direct that person to sign my name onto that record. And the notary will then notarize it, but also would need to be noted on the record that, it's so-and-so, signed by. There's a way to do this in the law. I got to look up the exact section of the law. It does get covered in our handbook as well, but there is a way to do that on the notarization. Oh, thanks, Robbie. 18208. I was almost there. I was at 18206. my neighbor there, Robbie, one of our other folks here, just gave me that info. If an individual is physically unable to sign the record, the individual may appear before the notarial officer and direct another individual other than the notarial officer who is concurrently appearing with the individual before the notarial officer to sign the individual's name on the record. If another individual is directed to sign an individual's name under that subsection, the notarial officer shall insert on the record the following words or words of similar import: signature affixed by, and then the name of the other individual at the direction of the name of the individual that directed that person to sign on for them. So this is what to do if a person's physically unable to sign. Some folks will just sign by mark, maybe make an X. That's fine, but they could direct somebody else to do that for them. This also, I should say, is different than somebody that doesn't have the competency to sign. Right? If somebody shows up before you, and they clearly don't understand what they're doing, and they don't kind of pass the competency test, and just get covered in a previous town hall, but they are not competent to execute a record on their own behalf, they can't have somebody else do it, right? Because this person coming before you is simply physically unable to sign. They're competent. They know what they're asking to be notarized. They want it. They want to sign and have it notarized, but they're just physically unable to sign it. That's this scenario. This is different matter from mental awareness and competency. The question. What else we got, Marquita?
Can you talk about the fingerprints? That's also coming up. It's still coming up.
Like in the journal?
That one first, yeah.
Yeah, in the journal. Fingerprints are not required in your journal. Not a requirement.
Someone was asking, could you replace a signature in case of the person cannot write for a fingerprint? Can use a fingerprint.
If they don't want you to fingerprint them, you can't, right? It's not a requirement. But the fingerprint is not required in the journal. I would tell you, like, fingerprinting, I don't know, I'm not certified to fingerprint folks, but I would imagine there's some special training to fingerprint properly, right? They don't just throw you in there and start fingerprinting folks. So I don't know how valuable that fingerprint is if you don't know how to properly do it anyway. I guess I'd say it that way. But it's not a requirement of the notary's journal. You don't need to have a fingerprint, and depending on whether or not you know how to do it, may not even be useful to you anyway if you don't know how to properly fingerprint somebody. But not a requirement. Never been a requirement. I know sometimes folks will have a line for that, or a journal might have a column for somebody's fingerprint, but it's not a requirement.
I have a question.
Hang tight. We're gonna catch you at the end, okay? If you are not Marquita, puts a little feature down there that allows you to raise your hand. Just click on the hand raise thing.
Got it.
We'll come through at the end and handle all those. Thank you. What else you got there, Marquita? Any other big themes or questions you've seen? And if not, we'll move on to those hands raised.
I just the last one about can a notary sign for someone a loan signing recertification, and they say how much do they charge? But yeah.
At the very, very, very beginning, I threw in a lot of disclaimers and disclosures. Loan signing agent, i.e. title insurance producer. Check with Maryland Insurance Administration. That's who regulates title insurance producers. That's how you become a title insurance producer, Maryland. You gotta pass through one of their classes and go through their application process. They give you the license to be a title insurance producer. Any title insurance producer questions you want to ask of the Maryland Insurance Administration, because they are different than us at the Secretary of State's office, and a Maryland title insurance producer's license is a completely different, separate thing from your notary commission. You may notarize stuff when you're acting as a title insurance producer, but the license itself and the rules and all are a different matter. I don't know what the fee schedule is for them. You might want to check with the Maryland Insurance Administration about any fee requirements for title insurance producers. Yeah. All right. Well, if that's all, hey, Marquita, I appreciate you monitoring that and keeping up with them. If somebody threw something in the chat box, we missed it, we didn't get it, feel free to throw it out to townhall.sos@maryland.gov. Shoot us an email. We'll get back to you. And like I said, even if you don't think of it now, this is not a speak now or forever hold your peace kind of situation. This is if you think of it a month from now, send us an email, dlnotary_sos@maryland.gov. Get those timely answers to questions. So right now, I'm actually going to stop recording. Meant to do this a little earlier, but stop recording, and we're going to go to the hands raised thing as well here and finish this out. So if you got your hand raised, hang tight, and I'll read off those names, and we'll take your questions one by one. Anybody that wants to drop off, feel free to drop off. Thanks for joining us today. We really appreciate it. I hope you learned something, or at least that it reaffirmed what you do know and gave you more confidence to handle what you're doing on a day-to-day basis as a notary. Thanks for your time, and if you got your hand raised, hang tight. We'll catch you next year. Thanks.